Welcome. Good morning and welcome. My name is Scott Gingler, and as most of you know, I'm the principal here at Wayzata High School. We welcome all of you who are joining us here today, whether here in our auditorium or watching via cable feed in the many classrooms across the metro, or you're simply tuning in at home. On behalf of the teachers, students, and all the staff of Wayzata High School, I welcome you. I also want to recognize and welcome our special guests who are here today, including the many dignitaries from multiple branches of public service and government. Students, if you could please join me in showing a respectful and warm welcome to the court and to the many men and women in public service, leadership, and government who are here with us today. Our collective goal at Wayzata High School is to equip our students with the skills and the confidence they will need to be happy, healthy, successful citizens even long after they graduate. Our motto is, we're here for you. By being here for us today, the Minnesota Supreme Court is truly fostering this work. I thank you for providing this amazing opportunity for our students. And now it is my pleasure to introduce the Chief Judge of the 4th Judicial District, Ivy Bernhardson. Chief Judge Bernhardson has served on the Minnesota District Court bench since 2007, and most recently as Chief Judge since last year. She received her Bachelor of Arts degree, magna cum laude, from Gustavus Adolphus College, and her Juris Doctorate, cum laude, from the University of Minnesota. Prior to her tenure on the District Court bench, she was Vice President and Chief Legal Officer for the Hazelton Foundation, an attorney and shareholder in private practice in Minneapolis, Senior Vice President and General Counsel for Medica Health Plans, and Associate General Counsel and Corporate Secretary for General Mills. She's also a singer with the Minnesota Chorale. Currently, Judge Bernhardson serves as a member of the Minnesota Judicial Council, the policy-making body for the Minnesota Judicial Branch. Please help me welcome your Chief Judge, Ivy Bernhardson.
Welcome to the students of our host school, Wayzata, the faculty of Wayzata High School, all of the dignitaries present, and court staff who have joined us in the auditorium this morning. A warm welcome to those of you in classrooms and members of the community who are watching these proceedings via cable television. This is a very special opportunity for you to view firsthand the highest court in the judicial branch of the state of Minnesota. As you may recall from your social studies classes, the judicial branch is one of 3 branches of our state government, the other 2 being the legislature and the executive branch. Many of you have been studying the court system and have had a chance to talk to attorneys who have recently visited your classrooms. The Minnesota court system is actually more than 160 years old, older than the state of Minnesota. It was passed by act of the Legislative Assembly of the Territory of Minnesota in 1853. Our court system is divided into 3 levels. The district court, where I serve as chief judge here in the 4th Judicial District, which is Hennepin County, Minnesota, headquartered in Minneapolis. District court is where most cases begin. We have everything from traffic tickets to murder trials. There are 10 districts in all in the state of Minnesota. As an aside, of course, Hennepin County being the most urban county in the state, we have 22% of the population of the state, but we have about 40% of all of the case filings in the state, so we are a very busy court. The Court of Appeals is the next level. We have 19 judges on the Court of Appeals who hear appeals from cases in the district court. And the final court of jurisdiction is the Minnesota Supreme Court, which has 7 justices who you will see shortly. So how does a case get to the Supreme Court? The Supreme Court hears appeals from the decisions of the Court of Appeals, the Workers' Compensation Court of Appeals, and our tax court. The Supreme Court also automatically hears appeals of all first-degree murder convictions directly from the district courts, and it also hears election contest disputes. The case you are going to see today is State of Minnesota Respondent versus Maurice Nathaniel Wilson, Appellant. Appellant Maurice Wilson was charged by indictment with aiding first-degree premeditated murder and aiding second-degree intentional murder. Wilson and the victim, along with 2 other men, were subjects of a federal indictment for conspiracy to sell heroin. The state's theory was that Wilson, acting from jail, instructed 2 other individuals to kill the victim in order to prevent him from providing evidence against Wilson. The gun used to kill the victim was found in a storage unit rented by one of the alleged shooters. Wilson pled not guilty, and a jury trial was held in Hennepin County. At the trial, the state used a peremptory strike to remove a prospective juror who was an African-American man. The defense challenged the strike as being based on race, but the district court ruled that a prima facie case of racial discrimination was not established. Also at trial, Wilson sought to introduce evidence to explain why the murder weapon was found in the storage unit by showing that keeping drugs and a gun together could result in an enhanced sentence for a drug crime. The district court concluded that the evidence was too speculative to warrant admission at trial. The jury found Wilson guilty of both counts. On appeal to the Supreme Court, the following issues are presented. 1, whether the district court erred in ruling that Wilson did not make out a prima facie case of racial discrimination to support a challenge to the state's peremptory strike, and 2, whether the district court violated Wilson's right to present a defense by refusing to allow Wilson to present evidence suggesting why the murder weapon was found in a storage unit. The case you will see today is a real case. Very important matters must be decided today, and it is critical that the justices and the attorneys not be distracted. Therefore, we ask you to abide by the very same rules you would if you visited the courthouse to see a case. And I assume you've all turned off your cell phones if you are allowed to have them in this school, and avoid any other additional noise. Any activity that distracts from the court process will be grounds for removal from the auditorium. Keep in mind, the total time for the oral arguments is about an hour. It's now time to convene court in the Wayzata High School auditorium.
We have one case for argument this morning, Wilson versus the State of Minnesota. Ms. Sheridan, you've reserved 10 minutes for rebuttal. You may proceed when you're ready.
Thank you. Good morning, Your Honors. May it please the Court. Ms. Burdorf. My name is Melissa Sheridan. I'm an appellate public defender, and I represent the appellant, Maurice Wilson. This case is the direct appeal of Mr. Wilson's Hennepin County convictions for aiding first-degree premeditated murder and an alternate conviction of aiding second-degree intentional murder. We've raised 2 issues in this appeal, but I'm going to focus my time today on the trial court's error in ruling that the defense did not make a prima facie showing of racial discrimination to support a challenge to the state's removal of a black man from the jury panel. The Equal Protection Clause of the United States Constitution prohibits purposeful racial discrimination in selecting jurors. And this means that parties may not use a peremptory strike to remove a juror based on the juror's race. When there is an issue during jury selection as to whether the prosecutor has used a peremptory strike to remove a juror based on a racial motivation, the district court is supposed to use a three-part test, which we commonly know now as the Batson test. First of all, the defense must make a prima facie showing that the strike was based on the juror's race. If the trial court finds that the defense has not made a prima facie showing of racial discrimination, then the inquiry ends with this first step, and the court overrules the challenge and allows the strike. But if the court finds that the defense has made a prima facie showing of racial discrimination, then the burden shifts to the prosecutor, who at that time has to articulate a reason for striking the juror from the panel. If the court finds that the reason is not race neutral, then the court sustains the challenge and the juror is allowed to sit on the panel. But if the court finds that the reason is race neutral, then the parties move to the third step, and at that point the burden moves back to the defense to prove that the race neutral reason is actually a pretext for racial discrimination.
There we go. It takes a rocket scientist to turn on a microphone. Counsel, before you get into whether or not a prima facie showing was established here, what if you're right? What happens to the case if you're right?
Oh, you're taking me right to the end of my argument. If I'm right, then I think what the court needs to do is remand the case back to the district court for a Batson hearing to finish the hearing on steps 2 and steps 3.
So your client is not released based on a prima facie showing?
No. If the court conducts the Batson inquiry at that point and then finds that the reason was race neutral, but then finds that there was purposeful racial discrimination, that it was a pretext, then he would be entitled to a new trial at that point.
Counsel, I'm going to take you back to the beginning of your argument. And, you know, given our appellate standard here, there's a high standard of clear error, and we're to give broad discretion to the district court. So what's the evidence here of any racial discrimination that could create that inference that gets you over really what is a pretty high barrier?
Sure, and I'm just going to back it up a little bit and remind the court, as you know, that the standard of review for each of the 3 steps of the Batson test is for clear error, which means that you defer to the trial court's ruling unless you find that the court clearly erred in making that determination. But the United States Supreme Court said in Miller L. versus Drecke that the standard is a demanding one, but it's not insatiable. So the other thing I think we need to look at is the different steps and consider that this court has actually applied a fairly, I'm not going to say loose test, but has been fairly forgiving in terms of findings of a prima facie case. And I think that indicates that we consider, the courts consider prima facie, the first step, more of a molehill than a mountain to get to the second step.
On the prima facie, and back to Justice Chudich's question on giving great discretion to the district court, particularly on the issues of credibility, and how do you overcome that, particularly in this case?
Well, I think I overcome that in a couple of ways. The first way is that the trial court didn't make very clear why the court found there wasn't a prima facie case. The court basically said, based on the responses, without indicating which responses, if it was the jurors' responses or the prosecutor's response, based on the responses, I find that there's not a prima facie case. But the court also noted that, agreed with the defense attorney's assessment that the juror had what the court called some experiences based on his race, but that the juror appeared to be fair. So those are the only things we know that the trial court found, that he had been subjected to racism in the past, and that despite that, he could be fair. So we know that from the court's ruling. So that's what you have in terms of the court's reasoning. But
Counsel, just to follow up on that, how much of that is really a credibility determination? I mean, one of the reasons why we apply clear error, I think, in Batson is because we're not there, we're not there and we have to defer to the trial court. It sounds to me like a lot of what happened before the trial court was the district judge making essentially a judgment call based on some of these things that you're talking about by viewing the witnesses, et cetera. And so I guess I'm wondering, how do we sort of second guess the district judge's credibility findings at this stage of the litigation?
Well, I think I'm going to disagree with you that we can say that the judge's determination of no prima facie case was a credibility determination. Credibility certainly comes into play when you're looking at the third step of the Batson test. If the prosecutor is given a race-neutral reason, the race-neutral reason doesn't even have to be credible, right? It doesn't have to be a good reason. It just has to be not related to race. But the district court looks at credibility in deciding whether or not the race-neutral reason is a pretext. But here at this first stage, particularly in this case, I'm not sure that we can say that the judge made a credibility determination because the prosecutor hadn't given any reasons for making the strike. So the only credibility determination that the judge said out loud was, the juror said he could be fair, and I think he's right. I think he's a smart guy, and I think he can be fair, and it's unfortunate he had those experiences. So,
Counsel, if I may, and this goes back maybe to Justice Lula Hogg's initial question to you. Let's assume you're right on the prima facie case, and that we conclude that the district court's finding was clearly erroneous, given the low threshold, essentially. That means, though, that then we're looking at Step 2 and Step 3, the prosecutor providing a race-neutral reason and your client having to show that that reason is pretext. Could we not, if we get to that, could we not, this court, make that determination in lieu of sending it back to the district court, given that it does seem to me the record is fairly clear because the state ultimately does put on the record to quote-unquote help the appellate courts if we decide to do this very thing, what its race-neutral reasons were. So that's my first question, and then I have a follow-up, but go ahead.
Sure. My contention is no, that you can't do that on this record. But also, the United States Supreme Court has indicated that if the judge errs in finding no prima facie case at the first step and ends the Batson inquiry, if the appellate court finds that the judge erred in that determination, the Supreme Court has remanded cases back. They remanded Batson itself back when they found that the judge had erred in not finding a prima facie case, and they remanded for the rest of the Batson hearing. And then almost 20 years later in United States versus Johnson, the Supreme Court did the same thing. They found the judge had erred in not finding a prima facie case, and then they said, well, the thing to do is to send it back.
To your knowledge, it's more of a question, to your knowledge, has this court or any court ever done the Step 2 and Step 3 analysis itself once there was a determination of clear error on the prima facie case?
To my knowledge, no. And I feel like I've read every one of your Batson cases more than once.
Okay.
And
that's helpful.
The state contends that you can do that and that you should do that. And the times that you do go ahead and do your own independent review and disregard the trial court's findings are cases where you found that the trial court erred in applying the Batson procedure, like skipping a step or collapsing the steps so you can't really tell which decision goes with which step. And in cases where you found that the court applied the wrong Batson procedure, you've said, well, we've got the record, we can make our own independent determination. Okay. But as far as I can tell, in cases where the trial court actually has followed the right procedure, and I'm not saying the judge came up with the right result, but the court definitely followed the right procedure. If the judge finds no prima facie case, then you're just supposed to stop talking.
Well, counsel, that leads me to my second question, which is, it strikes me that the state here can demonstrate, or at least there's an argument for it, race-neutral reasons for excluding prospective juror 29. One of the first reasons they give is they talk about his awful experience with the St. Paul police officer who pulled his weapon on him. And I think the state's position is essentially that wasn't about race. It may have happened because of his race, but what the state says they were really trying to get at is, what is this juror's predisposition to the police in general, and that is an issue that is race neutral because the state needs to know how people view police in general, given that many of their witnesses are often, and particularly in a criminal case, police officers. Why is that not a race neutral reason?
Well, again, I think it's up to the trial judge in the first place to decide whether or not that's a race-neutral reason. So that's my first response to that. But
assume we disagree with you and we decide
right,
to tackle it.
No, and that's fine, obviously. I would point to what this court did in State versus Pendleton, where the district court had found a prima facie case of racial discrimination when a minority juror was struck, and the defense had argued, look, this woman had a recent racially motivated awful encounter with a police officer. And I think that the defense counsel said, we think that's what shows a prima facie case, and the trial court agreed, and this court agreed that if you strike somebody for that reason, if you strike a minority juror who's had a race-based unfair encounter with a police officer, what you're assuming is that, and this is what the court said in Pendleton, you're assuming that a person who's subjected to racism will always have a grudge against the police and then take it out in the state.
But counsel, the problem with that is how do we separate, and Batson talks about race, about striking someone on the basis of race, but it seems to me that what Justice Hudson's question is getting at is viewpoints, and that might be informed by the person's race, but it's not a strike because of that person's race. I guess my question is how do we separate a juror's viewpoint from a juror's race for purposes of the Batson inquiry?
That's, I think, the biggest Batson question that we've been struggling with for 30 years. And I know that we're talking right now about whether or not that's a race-neutral reason, but I do want to remind the court that that's what happened in this case, and in Pendleton, in virtually the identical situation, this court said that raises an inference of racial discrimination.
Counsel, maybe the answer is you can't separate them.
Well,
I mean, you seem to suggest that in your brief. Or maybe it was defense counsel at the trial.
And I don't know how we do that, and I certainly don't know how we say to juror 29, right, you're a smart guy, you work really hard, you showed up eager to participate and take on the responsibility and the privilege that citizens have of being a juror in a really, really tough case. And you did all that, and we think you're awesome. But you can't sit on this jury because one time a white cop pulled a gun on you when you were sitting in your car while black.
But counsel, what about the fact that I believe the record was developed that it wasn't just that instance of his interaction with the St. Paul police officer, also the incident of his wife being a prosecutor, and there was a recent trial where there was an acquittal of a Minneapolis police officer, and he said that he felt that was just the wrong outcome.
Well, I think, again, if we're going to take on whether or not the prosecutor's reasons were race neutral, I think we have to look at what the juror actually said and then the reasons the prosecutor gave, right? And this court has said, notably in State versus McRae and then in other cases, that when prosecutors exaggerate what jurors said, then we need to take a closer look as to whether or not that's race neutral, whether or not that supports a finding of at least a prima facie case of racial discrimination. And here, and again, the prosecutor didn't give reasons for the strike until after the court had ruled. The juror was gone, right? At that point, they would have had to call a mistrial if the judge had changed the decision. They'd gone on with jury selection. So the reasons that the prosecutor gave after the fact, like I said, exaggerated some of the jurors' answers. For instance, the case that, or the situation you're referring to with the prosecutor saying the reason they struck the juror was because the prosecutor said the juror had strong views about the recent case that his wife had tried involving a police officer. But that's not what the juror said. First of all, the exchange was very, very short. And the juror said, I felt disappointed. Okay? He didn't say, I was outraged, I was incensed, I was crushed. He said he was disappointed, right? So that doesn't, it seems like an exaggeration to say that he had a strong view. And the prosecutor also said one of the reasons they struck the juror was because he had, again, quote, strong views about the police. But the juror specifically told the prosecutor when he was questioned about this that he didn't have any particular feelings about the police one way or the other. So there again, the prosecutor is exaggerating.
Counsel, what about the prosecutor's comment that he or she found juror 29 to be, quote unquote, quite liberal, whatever that means? But it does seem to me that an attorney has the right to select a juror based upon political ideology, and specifically political ideology that they think would be favorable to their case, and that could be race neutral.
Sure. Being liberal absolutely could be race neutral. Again, whatever that means, right? I don't know what the prosecutor meant. But here again, this is why we need the trial court to make these findings. If we've gotten over the prima facie hump, we need the trial court to make these findings, because the prosecutor can say, you know what, I have all these reasons, but here's my most race neutral one, right? Doesn't have anything to do with white police officers. It doesn't have anything to do with the juror being subjected to racism. It doesn't have anything to do with whether a black man views our system as disproportionately incarcerating black men, which it does.
Counsel, let me make the technology work here. All right. So let me move to the record, the trial record here, where the state asserts that it had kept a number of minority members on our jury, and that the defense had struck more minority candidates than it had. And of course, they point to the makeup of the jury as well, suggesting that that helps establish that there's no prima facie case here. I haven't heard you respond to those issues in the record and the actual composition of the jury. Can you deal with those issues?
Sure. The prosecutor said there's no prima facie case. I've kept a number of minority jurors. The number was 2. And then said, and by the way, the defense has struck some minority jurors, and again, that number was 2. So 4 members of racial minorities had been struck. The trial court found that the fact that the state had struck a second black man did not rise to the level of a prima facie case, but indicated if it happened again, I would take another close look at it. And of course, this court has noted that a subsequent strike of a minority member doesn't necessarily show a prima facie case, but it can indicate a prima facie case depending on the circumstances if it happens again. Here, though, we have other circumstances. It's not just that they struck a racial minority. And I'm going to circle back to your question about the racial composition of the jury as a whole. This court has said in State versus Reiners that when you're deciding whether or not the trial court erred, you can only look at what happened up until the point of the strike, because that's all the trial court had to work with. And so again, without findings from the trial court as to this particular, at this moment in time, Was it a prima facie case of discrimination? Were the reasons race neutral? Were they a pretext? Looking at what happened after Juror 29, I don't think is particularly helpful. Were other minority jurors on the panel, on the jury that ultimately tried the case, and I don't have an argument that there's been a disproportionate impact on a particular racial group in this case. My argument is based on what happened to this particular juror who had a 14th Amendment right to sit on this jury and not to be discriminated against on the basis of his race.
Counsel, I want to ask you about two facts, and I want you to respond because it's really a follow-on to what Justice Anderson was asking about. One is, and I think you mentioned this in your response, although you didn't cover it specifically, which is the defense counsel didn't challenge the strike of the first black juror, and what significance is there to that? And then also, what significance is there to the fact that one black juror was actually seated on the jury? At least that's my understanding. You can correct me if I'm wrong. And I'm wondering, for the prima facie case, now focusing solely on prong one, do those facts support or make it, or at least suggest that it wasn't clearly erroneous for the district court to have decided that prong one of Batson was not satisfied?
No. I mean, I understand the concerns about that, and the defense counsel actually explained what happened with juror number 22. That juror had apparently not put some prior encounters, maybe even conviction-wise, that he had on his jury form, and the prosecutor made a motion to excuse the juror for cause without even questioning him, saying, look, this guy didn't disclose his prior record. We think he should be gone for cause. And the judge said, no, I think he's just confused. And the prosecutor, again, without even questioning him, said, fine, we just are going to strike him. And defense counsel said, I really was tempted to raise a Batson challenge, but he said why he was striking him, and he hasn't struck any other black men off the jury. How am I going to make the case? I'm just going to move on. So she did bring it up at the time that they made the Batson argument on juror 29, saying that was cause for concern, and I think we should relate that back to what's happening now. But I also want to point out that there was another juror, juror 8, who the state accepted, who had also had a prior domestic-related conviction that had, not really clear on the record, or I don't think the record's very clear, but either been expunged or reduced to a misdemeanor after probation. She didn't disclose that on her jury form, and the prosecutor accepted her and didn't even ask her about that. Right? So if we're going to look at the record as a whole, I think we also have to consider how the prosecutor treated another juror who was not a black man differently than he treated juror number 22.
Counsel, if I may, you've argued in your brief that for purposes of the Batson analysis, the judge should not have, quote unquote, counted. I believe one of the jurors was a Liberian woman. And we heard that argument, a similar argument in Anya Loby, the kind of precursor to this case. And mainly because from your argument, there's a distinction between the experiences of African immigrants and those of African Americans born here in the United States. I tend to agree with you on that, but my opinion about that doesn't get this court very far in terms of our responsibility as the state's highest court to articulate a principled rule of law. And so my concern is, as it was in Anya Loby, what authority do you have for us to adopt that position? And what case law supports that position? What legal treatise or academic research supports that position? Because it does seem to me that quickly becomes a rabbit hole that probably should not be gone down absent some authority to do that.
Well, I hate to say this to you guys, but I got nothing on that in terms of authority. I will say that this was a concern that defense counsel raised in making the argument, but I recognize in Anya Loby in a footnote, you indicated that we don't think there's any authority for us to treat people of the same race differently for Batson purposes if they've had different cultural upbringing or background. And this takes us back, I think, to one of the biggest problems with Batson, and probably the biggest problem with race.
Counsel,
is
your time has expired. You
I'm
have
so
10
sorry.
minutes. That's
I
all
was
right. You have
looking
10 minutes for rebuttal.
Thank you.
Ms. Burdorf.
May it please the court, counsel. My name is Jean Burdorf. I'm an assistant Hennepin County attorney, and I represent the state of Minnesota. Context is critical when a district court judge is determining whether the circumstances surrounding the exercise of a peremptory challenge actually give rise to an inference of purposeful racial discrimination. In this case, the district court concluded that all of the circumstances surrounding the strike of prospective juror number 29 did not give rise to that inference. That ruling was not clear error. Appellant's Batson challenge should be rejected, and his conviction should be affirmed. There's 4 points I'd like to talk about with prima facie case. As the court knows, whether or not there's a prima facie case has 2 steps. One is whether a person or a prospective juror of color, one or more, has been excluded, and there's really no dispute in this case that that is met. The second is really a consideration of the context and all of the circumstances surrounding the strike of the challenged juror, and that is juror number 29. So I want to talk about the nature of the case, disproportionate impact, the composition of the jury, the nature of the prosecutor's questions, and the pattern of strikes. Those are the factors that this court identified that were relevant to the question of prima facie case in Untitled.
Counsel, I want to ask you about the standard. It seems that the standard for a prima facie case, given the burden-shifting nature of the Batson inquiry, is relatively low. And I sort of want to ask a preliminary question whether there's an argument that the district court raised the standard too high. In other words, may have applied a standard that was higher than is actually required to establish a prima facie case. And if not, why not?
Well, the standard is that there has to be, and this comes from Johnson versus California, it's a U.S. Supreme Court case from 2005, that this is how the Supreme Court articulated the standard. There has to be sufficient evidence in the record, all of the circumstances, to give the district court judge a reasonable inference that the real reason for the strike is purposeful racial discrimination. So that itself sounds relatively vague. With regard to the standard of review, so that what we do know about what is sufficient evidence to raise an inference is it does not rise to the level of preponderance of evidence. That is what Johnson says. I don't think that this is a district court judge who used an inappropriate standard for the inference. He looked at all of the circumstances surrounding the case. He made findings with regard to some of the questions and answers that were given, and concluded that all of the circumstances taken together didn't give rise to an inference of purposeful racial discrimination.
When looking at all of the circumstances, does that include then the demeanor of the prospective juror as well as the credibility of the arguments made by the state?
It does. In Onyelobi, it talks about the questions the prosecutor asks, the answers that are given, and the reasons that are given for the strike. Those are all factors this court can look at to determine whether or not a district court's ruling on prima facie case is correct. So if I may, I'll go through a couple of the factors your case law has identified. One is the nature of the case. This is a homicide case. Both the victim and the defendants are people of color, just doesn't have racial overtones. That is one of the factors this court looks at.
Counsel, let me cut right to the bottom line if I could. Is it your position that a prosecutor always has the right to exercise a peremptory challenge and strike someone from a jury based on the juror's viewpoint?
Based on their viewpoint?
Yes.
Yes.
Okay, so take this example. In a hypothetical case, there's questioning of a juror, and at one point the juror says, based on my experience as a black man in America, I believe there's racial discrimination in the criminal justice system. The prosecutor strikes the juror on that ground alone. Is that allowed under Batson?
The viewpoint, I mean, I think it really would depend on how clearly the viewpoint, I don't have confidence in the criminal justice system, is expressed.
Oh, he expresses it very clearly.
then I believe that's
based on his experience as a black man in America.
I think that is a viewpoint that is race neutral or not based on race, and let me explain. There's a couple different cases that I'd ask the court to look at on this point. One is Hernandez versus New York. That is a plurality opinion. Justice O'Connor wrote the fifth deciding vote. Her opinion controls, and what she essentially said is no matter how closely tied a person's viewpoint or belief is to their experience as a racial minority, that does not convert a party's strike of that juror into a race-based strike.
So it's your position that prosecutors can exercise strikes in a way that disproportionately impacts people of color, but that's not unlawful because it's based on viewpoint rather than their status as a person of color. Is that your position?
That is not my position. I think that if you look at a case like Batson, disproportionate impact has been considered by the Supreme Court in a number of different cases. Batson was the first one. Miller L. versus Dretke is a more recent one from 2005. In 2016, they had a case called, I think it was Foster, where they talk about disproportionate impact. And the way that that becomes relevant to the inquiry is this. In Batson, you see a prosecutor who uses 5 of their 6 eligible peremptory strikes to remove black men from a jury. In Miller L. versus Dretke, you see the same pattern. The prosecution used 91% of their available peremptory strikes to excuse people of color from the jury. That what the court has said in all of its cases and what this court has said is the way we look at disproportionate impact is what it reveals about the likely intent of the striking party.
So it doesn't violate Batson for the prosecutor to say, I struck every person who said that based on their experience as a black man, there's racial injustice in the criminal justice system. I did that, and it's based strictly on viewpoint, not based on race.
If the strikes are based on viewpoint, I think that under Batson and this court's progeny, as long as it is a viewpoint-based strike,
But counsel,
that is permissible.
Seems to fly. Did I lose my? That seems to fly in the face of what we said in Pendleton, which was precisely this case. A woman was, or similar to this case, a woman was stopped, a Hispanic woman, I believe. She thought that that was based on her race, and we said there was a prima facie case for that. And so this strikes me as seems to be a similar scenario. And I guess my biggest concern, and so I'd like you to answer that, but secondarily, my biggest concern with the state's position is that when you look at, say, quote-unquote, bad experiences with a police officer, lots of people have bad experiences with police officers. It's white, black, native, whatever. And some of that just comes from the fact that police officers are authoritarian figures. They impose their will. That's what they're trained to do. They're trained to take control of a particular situation, and sometimes we as the citizens don't like that. But the state's assumption seems to be because of that. When it's a black person making that statement, as Justice Hogg is alluding to, that person then can't segregate that view of what happened with that individual police officer from police officers in general, because we also all know that not all police officers are the same. And so that's my trouble with the state's argument, is that it seems to assume, when you talk about view, that we as human beings cannot segregate or compartmentalize a negative experience with one person from our general views about people in that general category.
Certainly, and I heard you ask a number of different questions, and so I want to, no, and they're all good questions that I really want to get to and I want to answer. So let me start with the first one, which is what about Pendleton? Is that this case? And I submit to you it is not. And that is why I started with context matters. In Pendleton, you had a prosecutor who struck the first person of color who was questioned in that panel.
So what? Isn't the rule that as a matter of equal protection, a juror is a juror is a juror, and this juror had the right and this defendant had the right to have a juror selected, not based or not excluded based on his race? Why does it matter whether that juror is the first or the second or the fifth?
The next sentence I was going to say is I actually contacted, the opinion doesn't say what that pool looked like. In Pendleton, I contacted the prosecutor's office down there, and the pool had very few people of color in it. The position that I'm articulating to the court, hopefully clearly, is that striking one person of color or two people of color in a jury pool that has one person of color or two people of color may raise a different set of inferences for a judge, depending on all of the circumstances. What we have here is a jury pool with 50 people in it. 15 of those people, or 30% of those people, were people of color. And so when you strike an African-American juror or an Asian juror or even two African-American jurors in a pool that has this composition, the inference that you might be acting with discriminatory purpose isn't quite as strong. And that is really what I meant about context matters.
And Counsel, aren't you just saying that it can't be a siloed response? I mean, am I right that you're saying that it is taking everything into account, and you could have prospective jurors who are not of color who would say that they have no trust in the criminal justice system
Certainly.
or they don't like police officers, and you would strike them for that viewpoint. Am I right?
You are exactly right. And that really gets to viewpoint versus race-based strikes. And I do think that as you look at a record and you look at all the circumstances, a distinction can be made. And I'd like to use the facts of this particular case to demonstrate that principle. And here's what happened. In this case, by the time we get to juror number 29, which is the challenge strike, the state had struck 5 people, 4 white people and 1 African-American man. And when you look at, this is what I believe the district court, where credibility comes in and what the district court was doing when it was making findings. The district court had the opportunity to see how the prosecution up to that point had been exercising its strikes. And what you see in the questioning, all the questions were the same. There was no deviation. This isn't a case like McRae. This is a case where the prosecutor asks the same questions, and the focus of all of his questioning is, how do you feel about the criminal justice system? How do you feel about the county attorney's office? How do you feel about the police? This is the meat of the questioning. He strikes juror number 12, who's a white man, who says that he thinks the criminal justice system is biased against minority people. That's a valid viewpoint. That we have no quarrel with that viewpoint. But that is viewpoint neutral to strike juror number 12. That is a white man who holds the same viewpoint that Justice Hogg existed in your hypothetical with the African-American man based on his racial identity and his history. Number 15 is a white woman, and she says the criminal justice system is unfair, and she thinks that money buys results. That is a viewpoint, that the criminal justice system is unfair. That is viewpoint neutral. That is a white person who holds that opinion. If you go to negative experiences with the police, there's juror number 37, a white man who was struck by the prosecution preemptorily because when he was 13 years old, he was playing in a park with a Nerf gun, and the police stopped him, handcuffed him, and he found that to be a very scary experience. So you have experiences that people of all colors and backgrounds have that can give them the viewpoint that the criminal justice system may not be fair.
How much can the district court take that into account? I mean, I understand we're talking here about the other jurors and not the particular juror that's being challenged here, but is the district court allowed to take into account all of these other, I guess, purported reasons? I realize that the prosecutor didn't articulate them because the prosecutor didn't need to, but can the district court at step 1 take into account all of these other strikes and all of these other reasons given, so to speak?
According to the precedent of this court, and most recently in Onyolobi, yes. The law is that the district court, when they're making this determination, can look to the pattern of questioning, the apparent reasons of strikes that have previously been used, and prior answers. I mean, that is a circumstance of the case. I mean, if you were to hold to the contrary, that would be absurd, which is essentially you have a district court judge who's watching this go down, sees that the prosecutor is using a consistent basis to strike 6 different jurors, they're all white, and you get to a person of color and uses the same reason to strike that juror of color, and you get a different result.
But in some ways that's guessing, right? Because the prosecutor isn't articulating the reason. I mean, you may be able to discern a pattern, and certainly, as opposing counsel says, you don't know the actual reasons for the strike of the challenged juror, the juror that's at issue in this case. So in many ways, it's the district court guessing, isn't it?
Well, I think it's not, for people who have selected a jury, is not really guesswork. You can look at the way that the defense attorney struck jurors peremptorily during this case, and you can make a really excellent, educated guess about what the basis is. Trial practice tells you what you're looking for when you want to pick a juror that, and admittedly, these are not strikes that are made because the person can't be fair. It's because either side thinks the person might be less fair to their side than some other juror. That's what we're doing. Prosecutors, including myself, when I pick juries, I am looking for people who have confidence in the criminal justice system, haven't had a lot of negative experiences with the police, like my office, like my boss, Mike Freeman. I'm looking for people like that. And when you look at this pattern of questioning, the district court is watching this and is, whether he articulates out loud that he's doing it or not, is making credibility determinations about whether the circumstances that he's seen up until that point, up until juror 29, really give rise to a reasonable inference that what the prosecutor is doing is discriminating based on race.
Counsel, you said that when you pick a jury, you're looking for people who have confidence in the criminal justice system. Based on your experience as a prosecutor, are you more likely to find those as white people or black people?
Well, I wasn't expecting that question, but I have a couple different answers. I think that people that have confidence in the criminal justice system come in all races, all backgrounds, all education levels. The last jury I picked was a while ago, but if you will allow me, I will tell this anecdotal story. It was a first-degree murder case. We were doing strike as you go, just like in this case, and we got to one of the last jurors, an African-American man who came from Chicago. The defense attorney asked him 2 questions and accepted them. Moved to me, I asked him a significant number of questions about his background. It turned out that he had been the victim of a gang shooting. He was the only witness and the prosecution wouldn't charge. He was very unhappy with that result, moved to Minnesota. And what I found out in my conversation with him is his biggest criticism of the criminal justice system was not that it was unfair to people of color or white people, it was that it wasn't vigorous enough, that we were letting people with guns and drugs out on the street, and that he wanted the prosecution to do more to keep his community, which was North Minneapolis, safe. He was my ideal juror, and he ended up being a critical part of that jury deliberation. The Washington Post.
Is the factor of confidence in the criminal justice system then, in your view, a race-neutral factor?
In my experience, I'm going to give you a true answer to that question. When I started practicing,
Well, I hope so.
I am. This is really personal. So, when I started practicing law in the 1990s, I don't know that I would have necessarily felt this way, but I have become more experienced. The jury pools in Hennepin County are so diverse, and it hasn't impacted our conviction rates at all. I think the lesson prosecutors learned, to the extent that in the old days people might have held some of these biases, I think experience has been teaching us over and over again the same lesson, which is confidence in the criminal justice system and desire to see people held accountable for crimes which are qualities that prosecutors are looking for really are race neutral.
Opposing counsel and I had an exchange about whether the composition of the jury itself could be or should be a factor that is considered here in terms of whether or not there's a prima facie case. I'd like to have you address that, and I think what Attorney Sheridan would tell me is it's only relevant to the point of the selection of juror 29. So tell me what the status of that was as of the time of the selection of juror 29 and whether or not that helps or hurts your claim here.
Well, what we have up to juror 29 is this pattern. We have one African American or black woman, juror number 8, who's been selected. We have one Asian man, juror number 11, who has been selected. The defense struck juror number 17 and 19, both Asian women. The defense struck juror number 22, who was 24, who was an African American man, and the prosecution had struck juror number 2, who was an African American man. So you have 5 people of color. Juror number 3 had been excused for cause. That is also an African American man. So in that first 29 people, we had 7 people of color questioned, 2 accepted, 3 excused by the defense, and 2 excused by the prosecution. I look at that, and I don't see, well, first of all, I see an incredibly diverse jury pool. I don't think that those circumstances give rise to an inference that the prosecution was somehow engaged in discriminatory racial jury practices. I mean, the prosecution really didn't even get to question 3 people of color in the jury. They excused juror number 22, but under Onyolobi, the fact that that wasn't challenged and there was apparently no quarrel with the basis for that strike really doesn't then make the subsequent strike racially discriminatory or create that inference that the defense is looking for. Did I answer your question, I hope?
Thank you.
Counsel, earlier you said you seemed to suggest that it mattered that there were no racial overtones to the case itself, that the victim here was, I think, Native American, and the defendants were all African American. But that isn't exactly true, is it? Because the juror has a 14th Amendment right to sit on a jury. And so I don't know how, initially I thought that's true. It's more important in cases where there's racial overtones, racial tensions, that kind of thing. But now I'm thinking that that should not be a factor.
Well, the factor comes from State versus Bailey, a case that I cited in my brief. So that's where this court has considered it in determining whether there's a prima facie case, and then again, whether there's purposeful discrimination. So I was relying on case law from this court. I think none of these factors, standing alone, are dispositive. I hope I'm being clear about that. I think that that's a factor a district court can consider. An inference of purposeful discrimination might be more readily made in a case where there's racial issues or there's some question of racial tension. That's the limited point that I'm making. Not that that somehow is dispositive, but it is just a relevant factor that the district court had in front of it and can be considered.
And your primary argument to us today is that the district court did not err in finding that there was no prima facie case. I mean, you're not urging us to go on to the next step. It's only a backup argument if we disagree with you?
My primary argument is that the district court did not commit clear error when it held that the state's perspective, a strike of prospective juror 9, did not establish a prima facie case of purposeful racial discrimination. Yes. That said, I will answer Justice Lohagg's question to counsel, which is, can you go to steps 2 and 3? Counsel's right. Batson is a case where the U.S. Supreme Court remanded to the district court. Pendleton and other cases, Reiners and some other cases, are cases where this court has looked at the analysis and said, I don't like the process used. I can't really tell what the district court was saying. In Pendleton, the district court judge never actually got explicitly to step 3. So sort of, it was just like this case. There was a step 1 analysis, a race-neutral reason given, and then nothing happened at step 3. And in Pendleton, this court went on and then considered, with an independent eye, the 2nd and 3rd steps of the Batson test. The court, to me, it appears from Pendleton the court can elect to do that. If you choose not to, then a remand to the district court would be the appropriate remedy. Certainly, our position is the only remedy that should be off the table is an outright reversal of appellant's conviction under these circumstances and this record.
Counsel, what about, I asked opposing counsel about credibility. So much of this is tied up in the behavior, the responses, the things people say in front of the district judge. Do you agree with opposing counsel made the point this really wasn't about credibility? Is that the viewpoint of the state, or does the state take a different view of the evidence?
I do take a different view of the evidence, particularly when the finding that the district court said is, listen, I've watched this, I saw the prosecutor's questions, I heard this juror's answers. I can't find that there is an inference that the strike of prospective juror number 29 was based on race, just given the circumstances. I think a district court judge cannot actually separate out the circumstances, which includes the pattern of questions, the pattern of strikes, people's responses, demeanor in court. I think it's just inherent in whether or not the district court ultimately finds that there's a reasonable basis to conclude that there is an inference of purposeful racial discrimination in the strike of the challenged juror. I just think it's inseparable. You can't, and that is in fact why the standard of appellate review is clear error, because great deference has to be given to the district court because the district court judge was the person in the room. My time is almost up. We do believe that the district court judge in this case made an appropriate ruling that should be affirmed by this court, and we would ask respectfully that appellant's conviction be affirmed. Thank you.
Thank you, counsel. Ms. Sheridan, you have 10 minutes for rebuttal.
Thank you, Your Honor. The main point that I want to address that counsel brought up was the argument that one of the factors this court looks at when you're deciding whether or not a prima facie case is made is the pattern of the prosecutor's questions, the way they treat other jurors or the way they've treated other jurors before they made this particular strike. Counsel brought up jurors number 12 and jurors number 14, white jurors who the state used peremptory strikes on, inferring that the prosecutor did so for the same reasons that they struck juror number 29, but I don't think that we can see that from the record because the prosecutor didn't ask those jurors any questions. Juror number 12 wasn't asked any questions at all. It was the end of the day at voir dire. Juror number 12 was up. The prosecutor said, look, I'm going to strike this guy. We don't even need to bother. And the judge said, thanks, now we can all go home. So that juror wasn't ever even questioned. So you can look at his form and see that he said he had some concerns about the criminal justice system, but we also see that he's a psychologist. And so maybe the prosecutor's like, we don't need a head shrinker on the jury analyzing everything in that way. We don't know, so I don't think that helps. I actually think it hurts that the prosecutor didn't question that juror about those things the way the prosecutors questioned juror number 29 about those same concerns. The same thing happened with juror number 14. Defense counsel had questioned her, but the prosecutor did not question her and struck her. And I believe this is the juror who said, you know, I think the system really works for people who have good lawyers. I'm concerned that maybe people with public defenders don't always get the best representation because they don't have as much time and resources. But again, we don't know why the prosecutor struck that juror. We can't compare his questions, their questions to her, to their questions to juror 29 because they didn't ask any. And also that juror had put in her form that she's friends with a public defender. So maybe that's why the prosecutor struck that juror.
But counsel, somewhere along the way, doesn't trial strategy play into some of these decisions, which is why the record is not developed from either side, perhaps on strikes?
I think what you're asking is that maybe the prosecutor didn't want to tip their hand as to why they're striking people, or
just that both sides have a trial strategy, and in
sure.
voir dire, obviously you know what kind of a juror you're looking for. So trial strategy plays into some of the decisions made as for when you're striking or not.
Absolutely, I agree with you. My point here on this is that if you're looking at how the prosecutor treated similarly situated jurors, we don't know that about jurors number 12 or number 14, but we do know about a couple of other jurors who had similar experience, and not similar because nobody had the same experience that juror 29 had, but juror number 1, a white woman, the state accepted her even though she had said she had compassion for minorities in the criminal justice system, and she also admitted that she had what she called salty feelings, which I take to be bad feelings, about the criminal justice system based on a particular experience that she had had. The state did not ask her any questions about those things. Okay? Not just as in-depth as juror 29, but not any questions. They asked her how she could judge credibility, how well she worked in groups, whether she could find the defendant guilty if the state proved its case. The state didn't ask juror 29 any of those questions.
Counsel, opposing counsel made the argument that the prosecution is always entitled to strike a juror. In other words, it's not illegal to strike a juror based on the juror's viewpoint, no matter how closely tied the viewpoint is to the juror's racial identity or experience. Do you agree with that?
I don't agree with that. But again, I think that's the really, really tough part of sorting out what to do with Batson issues and the question of racism in this country. And
well, it's a difficult question, but do you have any law on your side saying that a prosecutor is not entitled under Batson to strike on the basis of viewpoint when the viewpoint is closely tied to the juror's racial identity or experience?
No, and I think that...
And I think you answered that. I'm probably asking you the same question you answered in your principal argument.
Pointed out correctly that the United States Supreme Court has said, look, it might be related to race, but if it's not because of race, well, that seems like the kind of thing lawyers say.
In fact, under Batson, it is the test that it must be solely because of race, under Batson and our case law interpreting Batson.
Exactly.
Isn't that right?
Exactly. And I think one of the concerns, though, about when prosecutors say, well, we struck this juror because of his viewpoints about the criminal justice system, Juror 29 said, look, the criminal justice system in the United States disproportionately incarcerates black men. Is that a viewpoint, or is that the truth, right? So if we say, well, that's a viewpoint that he has based on his race, it's not a viewpoint, it's a fact, right? And he said, okay, I hold this viewpoint, but it won't make me take that out on the state.
So you're saying prosecutors cannot disqualify a juror based on viewpoint if the viewpoint is a fact? Is that your position? And if so, what kind of case law do you have to support that?
I don't have any kind of case law. And again, any reason is okay. Any reason is okay to use peremptory strikes as long as it's not tied to race, as long as it's not a reason based on race. If you say that a black person has
the test isn't whether it's not tied to race, it's whether it's solely because of race, isn't
based
it?
on race, absolutely. Yeah. And again, I think that is one of the toughest things that we're grappling with, not just in this case or in the criminal justice system, but just as a society as a whole, is how we marginalize citizens who are, well, everybody has to serve, but who are willing to serve and able to serve, and they get marginalized because they've been treated differently because of their race. And so we need to be brave enough, at least when we're talking about a prima facie case of discrimination, to say, man, this is close enough, especially when you look at the way the prosecutor treated other jurors who had similar situations and either didn't get questioned about those situations or didn't get questioned at all.
Counsel, let me change the facts just a moment, because this is a case it seems to me that the evidence, even at step one, is pretty thin. Suppose that this was the first, all the other facts are the same, but suppose this was the first black juror struck, that instead of the earlier juror, that this was the first time. Would you be making the same argument, or does a lot of your, or at least one of the facts, key facts that your argument hinges upon is the fact that this is the second black juror that was struck?
I don't think it hinges on that, but it's definitely a circumstance, and it aligns with this court's precedent that says we're going to look at all of the circumstances. So we have to look at all of them and list them. But if it was the first black juror, and it was based on the race-based encounter that the juror had, then I say Pendleton, because that's all we know from this court's decision in Pendleton, is that it was the first minority struck because she had a racially motivated, terrible encounter with a police officer. And this court said, yeah, that's a prima facie case because it assumes that people subjected to those kinds of things are going to hold that against the state and then not be a fair juror. So I just ask the court to reverse the trial court's ruling and remand the case for a Batson hearing. Thank you.
Thank you, counsel. Thanks to both counsel for the help that you provided to the court in this case. This matter is submitted. We'll issue an opinion in due course. The court's going to step off the stage now and take off our robes. Then we're going to come back out and talk with the students for a while. But before we step off the stage, please, I would ask the audience to join us in thanking the attorneys for the great job and for coming on the road with us today. Thank you very much, counsel. We're in recess.
So before we continue and have the justices back out here, I'd like to take a few minutes to thank those who have worked so hard to make today's program happen. First, I'd like to recognize some of our distinguished guests in the audience this morning. We have Mayor Ken Wilcox of the city of Wayzata. At least I thought he was here. And if there are members of the Wayzata City Council here, if they would stand, please. No? Okay. Well, we thought they were members of the Plymouth City Council. There we go. Thank you. We have members of the Wayzata School Board present, if they would please stand. Thank you. And we have Wayzata Superintendent Dr. Chase Anderson and members of the administration for Wayzata School District. Somewhere I thought was my colleague, the 4th Judicial District Administrator, Kate Fogarty, and I'm not sure where she went, but we work as a team in the 4th Judicial District. And if there are other special guests here today, welcome to you. I'd also like to thank the following people: Mr. Scott Gangler, the principal here at Wayzata High School. Yeah. Mr. Andrew Hagan, who's the communications specialist at the Wayzata Public Schools. And the members of the Planning Committee, who are Amy Swenson, Tyler Trimberger, Sue Iverson, Amy Parnell, Dave Elmhurst, and Dave Carlson. Thank you to all of those people. To the school resource officers, David Carlson and Steve Balloon, who I'm sorry if I butchered your name. Thank you. And to all of the students who are serving as our hosts this morning, each of us gets a couple of students to make sure we don't get lost here in this very large high school. So thank you to them. And to the Wayzata mock trial coaches and area attorneys who helped prepare the students for today's program. I have a lot of thank yous. Page 2. The attorneys in this case for presenting their arguments in a much larger setting than they're accustomed. I think we already thanked them, and they're probably back on their way to the office. To the Wayzata Police Department members who are here providing security, thanks to them. See them over there. To the EDTV for broadcasting, taping, and producing this morning's events. And a special thank you to the students who are assisting with the filming and stage setup for today's events. Thank you so much. Great. And finally, to all of you for coming today and for your interest in the third branch of government, the judicial branch. So now the fun begins. So the justices will be returning to the stage to answer your questions after they introduce themselves to you briefly. So if you have a question, you're going to be able to line up at the microphones. I'll put this one back here. And the Chief Justice will be calling on you. One very important thing you need to remember is they are absolutely prohibited under the Code of Judicial Conduct from talking about the case that they just heard or any other case in the courts. If they were to talk about this case or any other pending case, their comments could be interpreted as not being neutral, and either the appellant or the respondent might think they were being treated unfairly. But there are a lot of questions you can ask about their background, their experience, etc. So now, please join me in welcoming back the justices of the Minnesota Supreme Court.
Good morning, everybody. You were a great audience. Applaud yourselves. So I want to thank everybody with the school and law enforcement for being here. We've had a great day so far. Now we're going to spend some time with all of you. We hope you have Questions? And if you don't have questions, we'll randomly pick on you in the audience and ask you questions. That was a joke. It's okay. You can laugh. So, I'm Lorie Gildea. Delayed reaction. I'm Lorie Gildea. I'm the Chief Justice. I've been the Chief Justice since July of 2010. I've been on the court since January of 2006. Before coming to the Supreme Court, I was briefly on the Hennepin County District Court bench. I was a prosecutor in the Hennepin County Attorney's Office, a lawyer at the University of Minnesota, and then I was a lawyer in a large law firm in Washington, D.C. I went to law school at Georgetown in Washington, D.C., and I went to college at the University of Minnesota Morris. Justice Anderson.
Thank you. Delighted to be here. There we go. Well, they said it was on. Now it's on. Anyway, delighted to be here. I'm a son of Mankato. Grew up there. Graduated from Mankato High School, Gustavus Adolphus College. Did my law school work at the University of Minnesota. I spent most of my time as a practicing lawyer in Hutchinson and in Fairmont. I was on the Court of Appeals for 6 years, appointed by Governor Pawlenty to the Supreme Court in 2012, and I am delighted to be with you here today.
I'm David Strauss. I'm originally from Wichita, Kansas. I went to the University of Kansas for undergrad and for law school, and then I clerked for several judges, and you'll be meeting some of our clerks here. I think they'll be walking around with us later today. And then I took a job at the University of Minnesota as a full-time faculty member and was appointed to the Supreme Court by Governor Pawlenty in 2010 and then elected in 2012. And I just want to say we're really pleased to be here. I have two sons in the school district, so I'm particularly excited to be here.
My name is David Hogg. I grew up in Sioux Falls, South Dakota, went to Augustana College and then to Harvard Law School. After clerking for a federal district court judge, I was in practice, government or private practice, for more than 30 years, including 4 years as the United States Attorney for the District of Minnesota, the federal government's chief prosecutor and civil litigator in the state. I was appointed to the Minnesota Supreme Court in 2013 by Governor Mark Dayton and was elected to a 6-year term in 2014. One of my extracurricular activities is serving on the state mock trial committee, and I want to deliver a shout out to Wayzata Mock Trial today. It's a good program.
Good morning. My name is Natalie Hudson. I'm originally from Jefferson City, Missouri. My family moved here in 1968, so this is pretty much home. I went to Mounds View High School, and then I went to Arizona State University for college, came back home, and attended the University of Minnesota Law School. Most of my career has been in the public sector, including 8 years with the Attorney General's office doing criminal appellate work, so doing really what you saw the attorneys here doing. So I was privileged to argue many cases before both the Court of Appeals and the Supreme Court. I was appointed to the Court of Appeals by Governor Ventura in 2002, and I served on that court for 13 years until my appointment to this court in 2015 by Governor Mark Dayton, and I was elected in 2016 for a 6-year term.
Good morning. My name is Margaret Shudich. I grew up in Anoka, Minnesota. I went to Anoka Senior High, and at that time it was the largest school in the state, which I understand is now your honor. Really impressed with your school and how quiet you all were during our arguments, so thank you. I went to the University of Minnesota undergraduate, and then I went to the University of Michigan Law School. I have been on the court for this Supreme Court a little over a year. Before that, I served 4 years on the Court of Appeals. And before that, I had a really varied career. I was mostly in the public sector. I was a federal and state prosecutor. I also did appellate oral arguments. I was in private practice as well, doing civil work. I had a brief stint at the Humphrey School of Public Affairs, and one of my favorite experiences was clerking for a federal judge when I was first a new law student.
Good morning. My name is Ann Mikeg, and I am a proud descendant of the White Earth Nation. And I grew up in Federal Dam, Minnesota, population 108. And shout out to Eli and Jacob, who have been my, where are you guys? There's, okay. These are my people. this morning. These are my people, and they knew where Federal Dam is, so props to them, and they've been really great this morning. I was appointed to the court in September by Governor Dayton, so I'm the new kid on the block. Prior to that, I worked with Chief Justice Ivy Bernhardson, who's here this morning in the 4th Judicial District, as a district court judge for 8 years, and prior to that, I worked for the Hennepin County Attorney's Office, working in the Child Protection Division, focusing on Indian child welfare cases. So thanks for having us today. Your school is larger than my hometown.
Okay, do you have questions for us? What we're going to do is we'll alternate, and then we typically answer questions in order. So if you want to step up to the microphone, go ahead.
Hi, my name is Jay Clayman. I'm a senior. My Aunt Debbie Slavitt and my Uncle Brian Slavitt say hi to you.
Hi back. I love the Slavits.
Yes, so...
Their daughter rides horses.
Yes, so they wanted me to say hi for you. And then this is for all the justices. As someone who's aspiring to be on the Supreme Court, either of the Minnesota or federally, what would you recommend in the steps to take?
So the question has to do with what I would recommend to someone who wants to be on the Supreme Court. There are 7 Supreme Court justices, 19 Court of Appeals judges, 291 district court judges, some magistrates and referees. Licensed lawyers in Minnesota number about 26,000, give or take a little bit. Not all of them are practicing. And so, as you can see, the numbers don't favor this if you're setting this out as a career goal. I will tell you from my own personal experience, I didn't have that career goal. I think your career goal should be to find something about the practice of law, something that really excites you. And there are all kinds of things that a law degree can lead to in terms of community activity, as well as representing clients, as many of us did during our time in the private practice. And then you try to establish a reputation for professionalism, fairness, civility, aggressive and effective advocacy, and then you wait and see if the chips fall in place for you to someday serve as a judge. Perhaps they do, and perhaps they don't. And there's not much you can do about that except to say you've had a great career and you've accomplished a great deal and left a real mark on the lives of people that you've interacted with. And that ought to be your goal.
Thank you.
Hi, I was just wondering, what's the strangest or funniest case you've ever encountered?
Say that again, the strangest?
Strangest or funniest case you've ever encountered?
Boy, I don't know that I can pinpoint one. I will say that one thing that has struck me is, I don't know if you ever see in the paper, there's the news of the weird. Sometimes there's this column, and we do get some very weird cases. We've had some, it sort of reminds me that what they say on TV is true, is sometimes criminals aren't all that smart. And so some of the funniest things we see are criminals sort of doing things that are kind of silly. And so, that sort of immediately comes to mind. I don't know that a lot of what we do is really funny or silly to a great extent, because it's serious stuff. I mean, the stuff we do impacts people's lives, whether it's, a workers' compensation case that costs or that is about $1,000, or whether it's a first-degree murder case like you saw today. I mean, these are real cases that impact people's lives. But occasionally we do get some silly behavior by criminals. So that's probably the closest I can come to answering your question.
Go ahead. Hello, my name is Sagal Dad, and I'm a sophomore at Wayzata High School. And my question is, aside from judging cases, what are you guys' favorite hobbies?
Well, it's springtime, and it's time to go out on the golf course and be mediocre again.
Me too.
Justice Anderson is slightly less mediocre than I am. I grew up in South Dakota, and I like to hunt pheasants. So I do that in the fall after mediocre golf in the spring.
Okay. Hi, I'm Addie, and I'm a freshman. And my question is to second to last judge. Have you ever experienced any discrimination because of your race in the court system?
I was going to say, actually, it's my turn. Yes. I think, unfortunately, that's part and parcel of my reality, as it is for many people of color. But, I think no matter who you are and what your race, you will face various obstacles of various kinds. And the issue is, what do you do beyond that? And how do you overcome that? And how do you push beyond that? I will say that, fortunately, there have always been people around me, both black, white, and other races, who were supportive of me and who stood with me. And I think you will find that to be the case as well. And so you need to look towards those folks as your support system. But you have to have the backbone to say, okay, I've been knocked down or this has happened to me, but now what will I do? Will you stay there or will you get up? And sometimes when people treat you unfairly, the best revenge is to prove them wrong. And so you go about doing what it is you know you're capable of doing, and you succeed in spite of.
Okay, thank you.
So.
I'm Dhruv Mathi, a senior, and my question is, do you think the judicial branch has the either ability or responsibility to work towards social justice, or does that responsibility fall on legislators?
Well, our responsibility is to decide the cases that come before us fairly by looking at the law that applies to the case and also looking at the specific facts of the case. So I don't think, we don't have an agenda as a branch. I mean, that is our duty, to make sure that we treat everybody equally and everybody fairly in the context of that particular case. So I think it is more in the nature of the legislative branch, or possibly even the executive branches, to set out to achieve particular goals. But of course, our goal is to treat everybody, no matter who they are, and no matter the size of their case, to hear it carefully, consider it carefully, and decide it under the law and the facts of the case.
Hello, I'm Nick Salmon, a senior at Wayzata High. And I've always, this is my first Supreme Court case that I've ever actually seen. So I always assumed it would be like a lot of logos from both sides because it's more so based on pre-existing laws. Yet, after witnessing a case, I must ask, is it common for the defendant to use more ethos than logos compared to the prosecution? And do either have more influence towards the result?
So I'll take that question if you don't mind, Justice Mikeg. The argument that you saw today, of course, we're not going to talk specifically about the case or any aspect of the case, but the argument that you saw today is very typical of the cases that the court hears. We had two good lawyers, and we asked a lot of questions, and they answered them. And that's sort of the point of having oral argument. We call it an argument, but it's really meant to be a conversation between the lawyers and the court, where the lawyers are hopefully answering the court's questions. And it really is the beginning of the court's decision-making. What happens at the conference, we hear for the first time what our colleagues might be thinking about the case, or questions or concerns that they might have about the case. And so the decision-making starts in that way as part of the oral argument as well. But what you saw today is very typical of the arguments that you would see. If you watched us online, you can see us online, or if you came down to one of our courtrooms in St. Paul.
Thank you.
Over here.
Hey guys. Hey, just sorry. Little formality. I'm sorry. My name's Augustine Clement, and I have a question. Obviously. Sorry. Little nervous. Okay, so when you guys were in high school, or whenever you guys were in high school, I don't know the exact times, but when you guys were in high school, I don't know, I'm sorry. This is taking too long. Okay, when you guys were in high school, did you guys join the mock trial team? And if you did, can you, get everyone else to join too?
Well, in Reamer, Minnesota, we did not have a mock trial team because it was so long ago that I went to high school. I turned 25 times 2, thanks for reminding me by your question.
I'm really sorry.
But we didn't have that, but I wish we did have that. And so for those of you who, I think no matter what you're going to do, it is a great thing to join, because we will all say, as people who have interviewed people over our careers, Public speaking and the ability to articulate yourself is extremely important. And so there are benefits to joining the mock trial team, whether you're going to be a lawyer or not.
Thank you.
I'm Lillian Wood. I'm a junior here, and I had 2 questions, if that was all right. The first one was, at what point did you know that you wanted to be a judge? And the second one is, besides acting as judges, how else are you active in public service and politics?
So the questions were about when did we first know we wanted to be a judge, and what about other public service? So in my case, I had no thought of being a judge. I wanted to be a trial lawyer. I wanted to do what you saw today, lawyers arguing a case before judges, actually trying cases before a jury. And I had that experience for many years. And it was later in life, in my early 40s, when I began to think about maybe this could be something I could do. We'll let others judge whether or not I can do it. The second question about public service, that's a really great question. You referenced politics. Once we become judges, we're out of the political universe. We may have had some involvement before, don't have to have. Some of us have had some background in politics and elected office. Others of us haven't. But once we become judges, we're in the third branch of government: executive, legislative, judicial. We're in the judicial branch of government. And we don't get involved in partisan politics. But many of us still do a variety of volunteer and public service kinds of activities. Without going into endless and boring detail, you know, I've been active in Rotary, I've been active in my church and other activities. The same is true for all of us. And I just want to say a word. I can't resist the opportunity, having somebody put in a pitch for mock trial. Let me put in a pitch for high school debate and high school speech. There we go. See, there are at least 3 of us here who've had that experience. And it's a life-changing experience as well.
Hi, my name is Gargi. So like any other person, you have inherent biases. So how do you learn to control your biases when deciding a court decision?
So I think the question is, how do you control your biases when faced with a court decision? That's an excellent question. I mean, you know, every one of us comes from an entirely different background. I mean, and there certainly is overlap in some of the things that we've done, but, you know, I was an academic, various other folks were prosecutors, others of us practiced in a small town, and certainly we grew up in different environments as well. I think that the way to approach biases, I mean, you're a product of your experiences. That part of what makes you a good judge, I think, is to bring that experience to bear on the questions that are presented. But one way, I think, to control your biases is to understand that you have them, right? If you understand that you have them and you know what they are, then you can put them aside when you're trying to decide cases. And that's something that, actually, I used to be an academic. I wrote about some of this judicial decision making and things like that. And I think that the judges that tend to be the most effective are the ones that understand their biases and can put them aside. But it's a challenge. I mean, a lot of these cases can tug at your heartstrings. They're very serious cases with very serious consequences. It's a good question, but it's something that I think we all struggle with every day, but do our very best to put aside.
Hi, my name is Catherine Yu. I'm a senior. First of all, thank you for coming to speak with us today. So my question is, when should the judicial branch be ahead of public opinion, and when should they conform with public opinion when making a case decision?
Well, remember, the judicial branch is not to be influenced by public opinion. We don't do what's popular. In fact, under the Constitution, under the 3 branches of government that Justice Anderson described, it is the judicial branch that needs to stand up for minority rights, stand up for the rights of free speech, for example, when what you're saying may not be very popular, and stand up for the rights of criminal defendants, even when most of the public may have made a decision whether somebody is guilty or not guilty. And so it is precisely that counter-majoritarian influence that makes us what we are. It is also the reason why we need to keep partisan politics out of the judicial branch. We cannot be deciding cases based on whether the plaintiff is a Republican or a Democrat. We can't be deciding cases based on whether we think the majority of people will approve or disapprove of the way that we decide the case. That's one of the critical parts of our checks and balances, our divided system of government, and that's among the reasons why we are judges.
Hi, my name is Mohammed, and I'm a junior. So my question is, how are the judicial branch selected?
Yeah, I did.
How are the judicial branch selected?
How are we selected?
Yeah.
In Minnesota, we have what's called a merit selection system, and it is a system whereby the governor ultimately makes the judicial appointment, but he, in this instance, he does that after having had candidates vetted through this merit selection system. And so there's a judicial commission that interviews candidates, and so you apply whenever there's a vacancy. The commission will interview those candidates, and they will look at things like your reputation, your work experience, integrity. They will talk with references. So it's a very vigorous and extensive process. And then that commission will narrow it down to, say, maybe 7 or 8 finalists who will have another interview. Ultimately, 3 or 4 names are generally submitted to the governor. Let me back up one step. Our state statutes require that the governor use this commission for district court appointments, in other words, trial court judges. The governor's not required to use it for appellate positions such as the ones we hold or the Court of Appeals, but most governors in recent history have done that because they see the wisdom of that merit selection system, in large part to, and going back to the question Justice Hogg answered, to try to keep partisanship and politics out of the selection of judges as much as possible. I don't think that's ever completely possible, but as much as possible, so that it's based on merit. So at any rate, once 3 or 4 names go to the governor and his staff typically will interview those candidates and make the selection for the open seat.
Thank you.
My name's Finn Spire. I'm a junior. I have 2 questions, if that's all right. The first is, how close are you guys? Like, do you know each other pretty well, hanging out on a Friday night?
We're like this. No, we are very professional colleagues. We all appreciate and like each other, which is a real pleasure to be on this court. Your next question?
So the second question is a hypothetical, if that's all right.
Oh, boy.
Sure thing. So let's just say you were on the Supreme Court, and not this president, but let's just say the next president enacted a ban on, let's just say, 7 countries from entering from our country. Would you find that constitutional, just hypothetically?
Oh, I thought you wouldn't let me answer it.
You want yours?
I would have to hear the case. I don't issue any advisory opinions.
Next question.
Okay.
Hi, I'm Drew Severud. I'm a freshman. Okay, so that kid kind of took my question, so I'm like gonna have to figure out something on the spot. But like, when you guys like have disagreements, I guess, how do you solve them? Like, do you get?
We arm wrestle. No, we actually go back and forth, have a very professional, respectful conversation, and most of the time we're able to work things out. Sometimes there is disagreement, and that's when the decisions come out with a majority and a dissent.
All right, thank you.
Hi, I'm Madeline Earhart. I'm a freshman. And during the case today, the counsels kept talking about prima facie. I was just wondering what that is.
So the question is, what were the lawyers referring to prima facie when they were talking about prima facie? And so that means on its face. And obviously, I'm not going to discuss that case, but it is a Latin phrase, and it refers to a certain level of evidence that you need to have. And that's a really good point. We should think more often about answering those defining those terms.
Okay.
There is a dictionary.
There is a dictionary, correct.
Thank you.
It's on your phone.
Hi, my name is A.V. Riley. I'm a freshman, obviously here at this school at Wayzata High School. Okay, first of all, you guys look really nice. the outfits you guys, those two girls that were up there, they looked nice too. You guys had some really good outfits. Something I can't afford. Okay, back to my question. All right, thank you. All right. Anyways, so one thing I learned in life is that when we do things, we always have to make sacrifices in life. And whatever we do, like in college, I always learned that to make money, we have to spend money. Oh my God, college is just so expensive, and college is expensive, okay? And that's why people take out student loans and all that. But what sacrifices do you guys have to make as judges? What do you guys have to do to be successful and as far as in law school and all that? What sacrifices do you guys have to make? Like, is there anything in particular that's hard to be a judge, or is there anything that you guys have to deal with? Is that?
I can take it. You know, being a judge is hard work. Going to law school is hard work. I mean, you really have to spend a lot of time. You know, if you want to do a good job with the cases, because as I said, the cases are important, you got to spend a lot of time with the cases. And we have a lot of cases. We hear about, I think, about 110 cases a year, and write opinions in all of them, or almost all of them. And so, and the opinions aren't short. Some of them are. Some are 10 pages. That's probably 8 to 10 pages, probably the shortest. Some of them are 50 pages. And so, you know, it's really hard work that we do. I don't want to suggest that the job is only sacrifices, because there's wonderful aspects of the job as well. You know, I've got good colleagues. It's interesting. It's fascinating. We get to serve the public. All of those are very rewarding aspects of the job. But I would say the biggest sacrifice is time and hard work. I mean, all of us, everyone sitting up here, put a lot of time into getting here in one way or the other with our careers. But B, I think all of us spend a lot of time working on the job as well. So that's the biggest sacrifice.
Thank you.
Hi, I'm John Ayers Bautista. I'm a sophomore. I'd like to ask, basically, would it be better to decide to be treated equally or fairly? Yeah.
The question is, I'm assuming as a matter of values, is it better to be treated equally or fairly? Do I have a third option, which would be both?
I mean, I'm not sure. Like, which would you rather be preferred to be?
Let me just answer it this way. I can't answer quite that abstract a question, but what I can say is both of those values, equality and fairness, are found in our basic law. They're found in the United States and Minnesota constitutions. Indeed, the 14th Amendment provides for equal protection of the law. And equal justice is fundamental to our system, of the justice system in the United States. And in terms of fairness, we're constantly asking ourselves what is right and what is fair. Now, many of our cases provide the groundwork for doing that. When we're reviewing a decision of a lower court judge, we may ask, was the decision clearly erroneous? Was the decision arbitrary or capricious? Those are the kinds of standards that we apply every day as appellate judges. So we value equality, we value fairness, and we very seldom find an absolute contradiction between the two.
Hi, I'm Lauren. I'm a senior. First, you look very colorful, and I really like it. Now, the question I have is, you say you look at about 110 cases a year. How do you guys decide which case is more important over another case when you guys are deciding which cases to look at?
Well, I don't know if it's an issue of which case is more important than another. We have statutory criteria that guide our decision about what cases we will hear. And those criteria include things like, is it a case of statewide importance? So that, in other words, it doesn't affect just the particular parties that are arguing it, but it has statewide significance. Is it an issue of constitutional proportions? Was a constitutional issue raised? Is it an area where we're being asked to either develop the law further, or it's an issue of what we call first impression, and so we're being asked to create the law? And so those are some of the criteria that we look at in deciding whether or not to take a case in the first place. The other thing I want to do is go back to that other young man's question about some of the sacrifices and drawbacks, because one of the things that came to my mind, in addition to everything that Justice Strauss said, is I think sometimes people look at judges and think, oh, wow, you have this prestigious job, which it is. But being a judge is very isolating, and I don't think anybody tells you that, because people separate themselves from you, for better or worse. Your colleagues that you knew as lawyers suddenly feel like they can't talk to you anymore. And if you don't like, well, they do, because they're not sure what's proper to ask you or what's proper to say. And in some respects, you have to separate yourself from your colleagues because many of them will be arguing cases before you. And I don't think people look at that side of the job, is that it can be very isolating. And if you're not okay with that, it's not the job for you. Likewise, if you like, as Justice Anderson was saying, being involved in the political issues of the day, you give that up as a judge. You're saying when you become a judge, I'm putting on this robe of neutrality, and I don't get to go out and demonstrate at the Capitol, even though I may feel strongly about a particular issue. And you're saying you're willing to give that up in order to be a neutral decision maker of a particular case. That said, do we all love the job? Yes, or we wouldn't be here. But that's the other side of it.
Hi, I'm Samuel, and I'm a senior. I have a question for the white justices. Have you ever thought about how your whiteness limits your ability to have informed discussions about race?
What was the last? It limits my ability to what?
Have informed discussions about race.
Well, I think we mentioned this in our answer early on. Justice Strauss did, that it's really important when you sit as a judge to be aware of any biases that you may have. So I think we've all tried. I'm a part Croatian descent, which was unusual in my growing up in Anoka, Minnesota. But I think we all try to figure out where we might have particular implicit biases even. And what I do when I read cases, I never look at people's pictures. I don't look at the defendant's mugshot, for example. I don't want to know, if it's not apparent to me from the written materials, I don't really need to know about race unless it's an issue, in the case. So I take some steps like that just to keep it from even being an issue. But I think, we've all had experiences in life that have made us aware of what other people face. And so I think we all try to do our very best, despite the color of our skin, to appreciate what people are facing when they appear in cases before us in court.
Hi, I'm Shelby, and I'm a senior. I actually just finished writing my senior paper about a social issue, and I did it on social studies, education, and civic engagement in youth. And so obviously that's important to you because you came all the way here to hear a case in our auditorium. And so I'm wondering what you hope we learn from this opportunity and what you hope we do with that information.
Well, really, to become involved. I mean, that's one of the reasons that we do this, is to come out and educate the public and you, the youth, who are going to be our leaders of tomorrow, as to what the Supreme Court does and how important these decisions are, and your obligation as a citizen of the state of Minnesota to do all that you can to be a productive and respectful and engaged citizen. So I'm sure that's what you found in your paper. So we're hoping that you're all going to take what you saw here today, and it's going to propel you forward to want to become more involved.
Okay, thank you.
Hi, I'm Liam. I'm also a senior here. We already had some discussion about partisanship, especially in the judicial branch, but I'd like to ask one more question. We've seen the Supreme Court of the U.S. become a lot more partisan, and in general, the whole federal government seemed to be divided across party lines. I'd like to ask how the judicial branch specifically can act as a bastion against this.
So the questions about partisanship. I think the first cautionary note that I would offer is you need to be careful about what you read in the newspapers, and particularly what you see on television. So for example, when we report that the Supreme Court has become more partisan, that's an interesting question. I'm not sure it's true. I'm not sure it's not true either, but I can tell you that a fairly high percentage of their decisions are unanimous. That rarely gets reported. For our purposes on the state court level, I'll leave the United States Supreme Court to defend itself. For our purposes at the state court level, between 60 and 70% of our decisions are unanimous. And then we have varying degrees of disagreement on the remainder of these decisions. Disagreement is not a bad thing. It's not partisanship. And I think that is one thing that I think gets lost in the conversation about judicial decision making. They are legitimate disagreements about what the legislature intended, about what the Constitution provides, and what is the correct answer to a difficult legal question. The kinds of things that we do as a court to try to ameliorate any sort of partisanship or division is we try to be respectful about opposing points of view, both in our conversations in conference and in our writing. Sometimes we're more successful at that than others, since it's a human institution. But we work pretty hard at it, and I think we've been pretty successful. And I think for you, you folks who are going to be the leaders in the next 10, 15, 20, and 30 years, I think one of the challenges for the judiciary that's going to occur long after, it's going to be a problem long after I'm done, is whether or not we're going to be able to keep partisanship out of the judicial election process. Justice Hudson talked about how many of us are appointed to the court, but all of us stand for election every 6 years. Other states have struggled with this, and it's a real problem. It's a very complicated problem. I'm not going to take a lot of your time to talk about it today. There are arguments that run on both sides, the difference between independence and accountability. But how do you keep partisanship from bleeding into the judicial election process? It's going to be a very challenging question. So the question you're asking is a really good one, and it's deserving of a couple of hours of discussion, which we're not going to have right now.
Hi, my name is Smitha. I'm a senior. Kind of similar to Liam's question. So in the recent presidential election, we heard a lot of candidates kind of talking about how Supreme Court justices are quote unquote legislating from the bench, being activist judges. Is there any legitimate basis for this? Is this a legitimate concern, or is this just a way to erode faith in the judicial branch?
So I would say that those kinds of labels are not productive. I think they're very subjective. Justice Page used to say, who used to sit with us, and he reached mandatory retirement, he used to say that a judicial activist is a judge with whom I disagree. So it's very much in the eye of the beholder, whether somebody's legislating from the bench or not. And I don't find those labels really very helpful to the job of a judge. And so I tend to look at it more in terms of what is the job of a judge. It's to decide the case that's in front of her, one human circumstance at a time. You look for the law, you look for the facts, you take the law and you apply it to the facts, and you decide that case and you move on to the next one. And if that means that that judge is a judicial activist in your eyes, okay. And I'm not going to argue with that. This is America. People get to have their own views about things. I don't think it's particularly helpful. And I understand the political argument, and in some ways it's disappointing to me, because it does, I think, make people wonder about the job of a judge. And judges are not, as my colleagues have said, politicians. We don't wade into political issues. We decide the case that's in front of us, and we move on to the next case. Yes, sir.
Hi, I'm Nick, and I'm a freshman, and I was wondering, have any of you met Ruth Bader Ginsburg, and if so, what is she like?
Oh, this is a good question, I think, for me. So I had the unbelievable opportunity to be a law clerk, basically be an assistant to a United States Supreme Court justice. I clerked for Justice Clarence Thomas, and one of the traditions at the Supreme Court is that each chambers or each clerk gets to have lunch, or in Justice Ginsburg's instance, tea. We had tea with Justice Ginsburg during the afternoon. And one of my fondest memories at the court was sitting around her table in her office having tea. And at the time, her husband Marty was alive. And Marty is one of the best bakers. He made the best baked goods you could ever imagine. And so there's a big tray full of baked goods. And we just had a really normal conversation with Justice Ginsburg. And she is a very kind soul. I mean, she is a very sweet person. She's incredibly intelligent. She's wonderful to be around. And I've had the opportunity to sort of catch up with her. She was in Minnesota about 1.5 years or 2 years ago, and had the opportunity to talk to her again. And so she's a wonderful person. I really, really enjoyed getting to know her.
I'm Ashmita. I'm a senior. And I was wondering, with the appointment of the new Attorney General, what potential impacts do you think Because like even though it's a part of the executive branch, do you think it could have any potential impacts on either the federal judicial branch as a whole, or the state judicial branch?
And the question was about the U.S. Attorney General? Yes, the United States Attorney General is the chief law enforcement person in the United States, administering the Department of Justice. And the new Attorney General is former U.S. Senator Jeff Sessions. I appreciate your question about the U.S. Attorney General because I was the United States Attorney for Minnesota and reported to the Attorney General. Back then in the Clinton administration, it was Janet Reno. The U.S. Attorney General really has an enormous opportunity to influence law enforcement policy in the United States. The Attorney General may decide, for example, federal prosecutors and federal agents such as the FBI, the DEA, and the ATF should be focusing more on this kind of crime rather than on this kind of crime. And some of that is a matter of policy. And some of it is a matter of reacting to different kinds of crime that are emerging in our society. So back when I was U.S. Attorney, we had very little cybercrime. Clearly, that is a massive thing now. And this administration, as I understand it, is going to be focusing on cybercrime, and most certainly I think everyone agrees that they should. Did that answer your question?
I was wondering if it would have any like impact on the judicial branch or the work that
Well, the Attorney General has an impact on the judicial branch of the federal government because it is within the Attorney General's office, or more accurately in the Department of Justice, that you find all the prosecutors and find all the government attorneys. And the positions they take in court will, of course, influence how the case is argued, and ultimately, if they're persuasive or non-persuasive positions, will affect how the federal courts rule.
Okay, thank you.
My name is Shuaib Hussain, and I have a question. How much money do you guys make?
So the Chief Justice gets paid somewhere in the $180,000. The Associate Justices make a little bit less than that. The trial court judges in Minnesota make about $149,000. Judges, it's interesting though, it's a great question because Minnesota judges rank about 20th or so in the country in terms of their compensation. And judges in Tennessee and Arkansas, whatever you want to think about Tennessee and Arkansas, they make more than judges in Minnesota. Next question.
Oh, thanks.
Hi, my name's Tom, and I'm a freshman here. What was the most difficult situation that you have had to overcome to obtain the position that you are right now?
The most difficult situation I had to overcome to attain the position? I think you have to be persistent and persevere. I think it goes to Justice Anderson's point earlier. Even once you decide that this is a career path that you want to take and you want to be a judge, I applied for a previous position on this court and didn't get it. And so that's discouraging. And it feels very personal when you've worked so hard all over your career and whatnot, but it isn't personal. And so there are disappointments along the way, and I think that's true for anything any of you ever want to do. You will not always be successful, even if you are generally a successful person, and most everyone on this stage is and has been successful in their career. But there are disappointments in life all the time, and so you pick yourself up and you figure out, okay, do I still want this position? What do I need to do to get that position? And you try again. And so some of it, and I think that's true again throughout your career as a lawyer, or whatever you may choose to do, is being persistent and to persevere through the inevitable ups and downs that life brings your way. So,
thank you.
Hi, my name is Kaylee and I'm a senior. For those of you that had the opportunity to argue in front of the Minnesota or the National Supreme Court before becoming justices, what impact has that had on your time on the bench?
I had the opportunity, I haven't argued at the United States Supreme Court, unfortunately, but I had the opportunity to argue many times before our state Supreme Court and the Court of Appeals. And I think that was useful to me in now being on the other side of the bench. But it was funny because the very first argument I heard on the other side of the bench, I wanted to ask the counsel a question. I said, "Excuse me, Your Honor." So in that sense, it wasn't helpful that I had previously argued in front of the court. But I think you get a better sense for what the attorneys are going through and what they need to know. And we're fortunate in Minnesota. Most of the, especially at the Supreme Court level, most of the attorneys who we hear are like the ones you saw today, who are very well prepared. They knew their cases. They knew the facts of the case. They knew all about juror number 7. So that's a real privilege to have that kind of representation in front of our court, and it helps us to make better decisions when the counsel is good.
Thank you.
Okay. It's not a very good one. Is it typical for justices appointed to appellate courts to have had some sort of relationship or connection to the governor prior to the appointment?
Well, I think it really depends a lot on the circumstance. Some of us, I think, knew the governor that appointed them, and some of us met the governor for the first time when the governor was interviewing us. So it really varies. I mean, Justice Hudson described the merit selection process. Justice Anderson mentioned that we're all elected. So our own personal stories vary quite a bit. Thanks for the question. Thank you all. You've been a great audience. It's your turn now, Principal.
So students, I hope you are feeling as privileged as I'm feeling right now to have been witness to this, to be a part of this. Obviously, you know the challenge that they have in their role. I would argue it can even be more difficult when you open yourself up to a forum of high school students asking questions. And with that, I would like to thank you for providing that opportunity as well. It's been such an amazing day today. I have good news and bad news for all of you. The good news is you were able to be witness to such an amazing, amazing event. The bad news is there's still time to get to your second block class. So you are now dismissed to second block. Student tour guides, if you could join your justices back in the robing room, that would be great. Thank you.